For those, as I was saying, for those who have elected and are being permitted to appear by Zoom, you cannot be in a vehicle. If you are in a vehicle, you have two choices. You can exit the vehicle and find a quiet place to participate by Zoom, or you can drive on down to County Court at Law Number 2, located at 300 De La Rosa, San Antonio, Texas, 78205. We're on the first floor of the Kadena Reeves Justice Center. Your name must be displayed, first name and last name. And you must have your video on. You must appear. The people in the courtroom are here, present, appearing. I can see their faces. So by Zoom, your appearance is by video. We are operating hybrid, meaning I have people in the courtroom as well as those who have elected to appear by Zoom. If you are in a vehicle, you have not displayed your name, first name, last name, and you don't have your video on, I will not recognize you until you cure those mishaps. Will you go ahead and get out of the vehicle, find a quiet place to participate, display your name, first name, last name, and fix your video and audio, then I will recognize you and I will mark you as late. Zoom has a chat feature. You cannot use that chat feature without my permission. You cannot chew gum, eat, drink, or smoke or vape during Zoom. If you cannot do it in the courtroom, you definitely cannot do it by Zoom. You cannot leave the courtroom or the court session without being properly excused or dismissed. If you do need to go someplace, please make sure that the deputy knows that you check out with the deputy. For those on Zoom, please feel free to go ahead and chat to the deputy if you need to leave and come back. You need to place your device on a flat surface and place yourself on the center of that device. Please do not move around with your device. I will call your name. I will call your name 2 times. If I mispronounce your name, please do go ahead and correct me so that I may make my best effort to pronounce your name correctly. Also, once I call your name, I'll need for you to respond. You can unmute and respond here or present. Here or present. For those in the courtroom, I expect you to stand and respond here or present. I will then ask you, verify that you have attorney representation. If you do not have an attorney, I will ask you to see if you wish to hire an attorney or do you need to apply for a court-appointed attorney. After that, you can sit down or you can mute yourself if you're on Zoom. For those of you in the courtroom, they're sitting up, and I expect those in the Zoom to also sit up. So I will finish calling the docket. I must finish calling the docket. Once I'm done calling the docket, then I will proceed to move the attorneys who need to speak to the ADA I will move them to go ahead and speak with the ADAs. I'll move them in Zoom. And then I will handle individual matters. All these instructions that I have presented to you, any violations of these instructions are subject to contempt of court. There's a court order of the day. So today is Tuesday. It is the 12th day of July, 2022. Deputy, anybody else coming in after this is late and needs to go in the jury box. It is 9:19. I start to call. I'm looking for these folks. Eliud Martinez. Eliud Antonio Martinez. Mark that as failure to appear. Joel Chavez. Joel Adam Chavez.
Good morning, Your Honor. I'm here for Mr. Chavez. He's in custody.
Thank you. I have him showing as bond.
He's out on, he has 3 cases, Your Honor, 1 felony and 2 in your court. He's out on bond for 1 of the 3. The other 2 he's in custody for.
Okay. All righty, be right back with you. Thank you, counsel, for being here for your client. Stephanie Carrillo. Stephanie Marie Carrillo. Andra Maxwell. Andra Bernard Maxwell. We'll go ahead and mark that one as failure to appear. Hector Ludek, Luduc. Hector Alejandro Leduc. Mark that one as failure to appear. David Sanchez Cruz.
Good morning, Your Honor. He's present with counsel.
Good morning, counsel. I have Stephen Ramirez as
Yes, Your Honor. Yes, Your Honor. I work in his office. My name is Monica Kretschmar.
Okay.
And we're present today and we'll be ready to move forward with a plea today.
Okay. And you pronounce that last name Kretschmar?
Kretschmar, that's correct.
Thank you. And Mr. David Daniel Sanchez Cruz, I need for you to respond, unmute and respond.
Your Honor, he's a Spanish speaker. Would you mind if I were to tell him in Spanish? He's here in my office, but he's in the waiting room.
Oh, sure. Wait, your waiting room or our waiting room?
In my waiting room. So would you mind coming back to us? I just need to go tell him in person. He's not so tech savvy, but he is here and available.
Please go ahead and get him set up.
Thank you.
Yes, ma'am. And Ana Marie Garcia. Ana Marie Garcia.
Yes, ma'am. Present.
Ms. Garcia, you
Yes,
need to
ma'am.
put that device on a flat surface
Yes, ma'am. Right here, ma'am.
and place yourself in the center of it.
Yes, ma'am.
That's perfect. Thank you. Let's
Yes.
keep it like that, okay?
Yes, ma'am.
All right. Is your attorney Joseph Stetson or Monica
Your-
Guerrero?
Yes, Your Honor, may I have,
Okay.
may I-
That's all I need for right now. Just
Oh.
need for you to acknowledge your attorney, okay? All righty. So your attorneys, Monica Guerrero, Joseph Stetson has shown for you, correct?
Yes.
Okay, thank you.
I-
Thank you for being here.
Yes, ma'am. Thank you.
Don't wait for them.
Yes, ma'am. Judge, I was supposed to be there in person. You told me,
Miss Garcia, hang on 2 seconds. Let me finish my docket, and then I will attend to individual matters, okay?
Thank you.
That's what my instructions said.
Yes, ma'am.
Thank you. Elijah Gonzalez. Elijah Gonzalez. He should be here at 10 o'clock. Ms. Luna, he was ordered for 10 o'clock, right? Okay, is there anyone in the courtroom that has not heard their name called? Stand up. If you have not heard your name called, stand up. Starting left to right, what is your name? What's the last name, please? K-R-E what? And what's your first name? All righty. And who's your attorney? Michael who? Okay, thank you. All righty, go ahead and have a seat. Thank you for being here. Yes, sir, your name? What's the last name? Pineda?
Yes.
And what's your first name, sir?
Homero.
And who's your attorney, sir?
Thomas Hill.
All righty, thank you, sir. Thank you for being here. We'll wait for your attorney.
Excuse me, Your Honor.
Yes, ma'am.
I just wanted to inform you that defendant David Daniel Sanchez Cruz is now, his video is turned on, so you're able to see him.
Okay. David Daniel Santa Cruz.
Presente.
Thank you very much, sir. Thank you for being here. Daniel McDonald. Okay. Counsel, is there any way that you can go ahead and get your client here to join us by Zoom? Okay. Okay, on Zoom, is there anyone that I have not called their name or recognized? Is anyone on Zoom that I have not called their name or recognized? All righty, that concludes the calling of the docket. All right, any attorneys that need to speak with the ADA?
Yes, Your Honor, if I can get a breakout room to talk to a prosecutor.
Alrighty? And at ADA BOSIS,
Yes, Judge.
good morning, sir. And I still just have you as the solo ADA that I have for
Yeah.
today?
Yes, that's right.
Okay, all right. So knowing that, Mr. Lamas, don't hold him too long, okay?
It shouldn't be too long, Your Honor. He has a pending felony.
All righty. Attorney Strickland, do you need to speak to the ADA?
No, Judge, we spoke yesterday. About the question. I've sent the new information just to McDonald. Probably, I think some shit I can pull it.
Oh, he can get to where he's going. He can get to where he's going.
He's probably coming here to.
Oh.
Being here at 10:30.
Okay, well, then let him come here. That's fine. Then allow him to come here. I'll just hear the motion once he's here. Yeah, please. Take his number.
Your Honor, may I approach?
Yes, yes, Council, please, all, be aware that, Zoom has had the latest Zoom update, I guess, caused a little bit of a problem in that when you're coming out of the break room, make sure to select leave break room. Otherwise, it's bouncing you out, or it may just be bouncing you out even if you select leave break room. So it's a glitch with Zoom, but go ahead and come right back in. We'll let you in. Okay, Council Lamas?
Yes, Your Honor. I conferred with the ADA, and my client currently has a pending felony that we're set for next Monday in the 227th. We're just asking for a reset to see what we can do to resolve the felony first.
Let's go ahead and set it with that felony, so we'll go ahead and track them together, track all the cases together. Would that be okay?
Well,
Is he having two separate cases? Two separate? It's 227th. Yeah, I see it. It's been indicted.
yes, yeah, we're set for it on Monday. Can I have the setting in the 227 separately on Monday and then inform the court later that day when they set it, if they do set it? We may get it resolved Monday, but whenever we get a new setting for the 227th, can I just inform the court and push it out till then?
Right, we're going to go ahead and reset this one for Monday. Counsel, if he gets out, all he needs to do is come check in here at 8:30, 8:25, and then
So-
run up to 227th, and we'll wait for you to tell us what happens. We'll just
Okay.
track it with the felony.
My client is currently in custody. I don't think he's getting out anytime soon.
Okay.
Unless we get something resolved. Is my client in one of the breakout rooms or in a waiting room?
And no, did you ask for him to be brought over, sir?
No, Your Honor. I just,
Okay.
and if it was.
Okay, not a problem. We had him as bond, so that's probably why we did not, there was no indication to bring him over, except for the one case that's in jail. But what we'll do is on Monday, if you just drop by and let us know if he doesn't get out, what the next setting should be, okay?
Okay, it may be toward the noon area, but I will inform the court.
That's not a problem, and counsel will at least order him if, for Monday, just in case. I'm sure if the felonies are going to order him.
Yeah, the felony's probably gonna order them. Can we just hold off on ordering him on the county court 2 side? I don't want them to get confused.
That's not a problem, okay? Monday. Okay,
With that, Your Honor, may I be excused?
yes, you may. Thank you very much. And he's in jail. Okay, felony pending. Have a good day, sir.
Thank you, Your Honor. You too.
Attorney Sawyer? Good morning, sir.
How are you?
I'm fine, thank you.
I'd like to go to a breakout room if I could, in the case of Eliud Martinez, case number 660079, Your Honor.
Just getting feedback.
Yes, sir. Sir, he did not answer the docket.
He is on Zoom, Your Honor. I know he's there.
He's in the lobby.
He's logged.
Alrighty. Okay,
I just saw him on the screen, so I know he's logged in.
Eliud Martinez? Unmute and respond.
See if you can get Eliud to.
He's right there.
Okay, there he is.
Yes, ma'am.
Alrighty. Sir, you're late. Please don't do that again. Don't be late again.
Your Honor, if
Okay.
I may, he's been in my office all this time. I was delayed. There's a big wreck on Lake Loop 410 West. And
Ooh,
all the lanes were shut down. I was stuck on the freeway. And I
Oh.
just got here the last 5 minutes, so I apologize.
okay. Not a problem, sir. And you wish to go ahead and get into a breakout room and speak with the ADA?
Yes, ma'am, see what we can do.
Okay.
And I will tell the court, Eliud has actually been in my office waiting on me to get here.
Okay. Alrighty. Mm. You should have your invitation, sir. Brett, do you need for me to invite you again? Okay. Okay, this is a good time to call your attorneys. If you have not seen your attorney or spoken with your attorney today, please go ahead and call your attorney. Attorney Crashmar, I'm sorry.
Hi, Your Honor. Yes. We're ready to move forward on a plea today, but I'm aware that the attorney Ramirez appeared last week, and it seems like the court didn't have all of the documents in order. I was wondering if you could confirm if the court has received those already. I have the filled out personal data sheet, but we filled it out in person today, so I can forward that to the court coordinator. I can scan that to her if it's not in the record yet. I just want to make sure we've got everything in order.
Okay, there is some interference with your communication. There's a lot of noise with it whenever you're speaking, just to let you know. And it's going to be very difficult for me to understand and difficult for the court reporter to understand.
I understand that, Your Honor, and I think I know what the issue is. Give me just 1 second.
Okay, thank you. And I'll put you in the breakout room with the court coordinator, court manager, see what she can do to help you with that personal data sheet. Okay, counsel? Counsel? Just give me a
Yes, Your
thumbs
Honor.
up.
I'm trying to
I'll
figure
put
out
you in the
this handling
breakout
issue.
room to talk with the court coordinator to help you out with that personal data sheet, okay?
Thank you.
Thank you, ma'am. Mr. Martinez, I'll need for you to place that device on a flat surface and place yourself in the center of it, okay? And leave it alone, okay?
Is that better, Your Honor?
Oh, where is it? Yes, sir, thank you.
You're welcome.
Okay. Have Joe Washington, let me put him on here. He's not in the supposed to be in the 399? Okay. Right? And not County Court 11. How about County Court 11? There's a mistake that sometimes.
Yeah, when I left the manager, they looked it up and they said, "County Court 2."
Great.
This is a ticket, that means.
What's your name, sir?
Gerald Washington was Jerald. Last name Washington, like the president.
And do you have an attorney, sir?
I mean, this will be my first time seeing somebody.
Okay, not a problem, sir.
Excuse me, Your Honor.
Yes, Attorney Crashmeyer?
Yes,
Crashmeyer?
Frenchville. Your Honor, I just spoke to Ms. Luna. It seems like most of the paperwork is in order. I have to scan something to her. But my client is a Spanish speaker and we will be using an interpreter. She informed me that that interpreter won't be called until 11. Would it be possible for me to log off of the meeting and log back on at around 10:45?
Oh, okay, thank you.
Okay.
And please, if you will check the Spanish version, it is not compatible with the English version.
Do you mean the paperwork?
I have the paperwork and it's not in concert. It's not congruent with.
Yeah, Ms. Luna just sent those documents to me. Let me review them and see if there's some corrections that have to be made. So I'll be in contact with her.
In the Spanish version as well as the English version, just make sure that the plea is correct.
Okay, let me review that and I will make some corrections.
Thanks.
Thank you, Your Honor. I'll be logging off, but I'll be logging back on at around 10:45 in preparation for the interpreter and the plea.
Okay, probably more like 11 would be good.
11? Okay, that sounds good. Thank you, Your Honor.
Thanks. Yes, Attorney Sawyer.
Good morning, we're back, Your Honor. I have conferred with Brett, the ADA, and he has made us an offer. I've explained to him that due to the mix-up about who the attorney of record was in this case, we're just now getting our discovery. I would like a short recess if the court permits, 2 or 3 weeks. Look at the video, go over the evidence, and I believe this case can be resolved on the very next court setting.
hang on 2 seconds, please. Deputy, would you tell?
I need to bring it in to correct that. Okay. Yeah, we did our notice back in October 2021. I'll get David, get everything done, do it tomorrow morning.
Counsel,
Yes, Your Honor.
Attorney Sawyer, your
Yes.
client has an active warrant. He'll need to come in and turn himself in.
Oh, we will do that, Your Honor. Probably do that first thing in the morning. I think what occurred, if this is a bond forfeiture, there was a town who received no notice. Notice went to Shannon Locke rather than Michael J. Sawyer. Nonetheless, I'll present him in the court tomorrow morning with a motion to set a bond.
Okay, and from then we'll go ahead and deal with his case.
Oh, absolutely, Your Honor. But first things first, we have to get him there, get him surrendered, bond set, and we will see you in the morning on that issue, Judge.
Okay, you
No.
can't do that this afternoon?
Well, I could try and prepare the motion for the new bond and surrender him, but my brother David will not be available to make the bond for me this afternoon.
All righty, sir.
But in the morning, this will go tomorrow morning, we'll be there with bond in hand and just have you set an amount that's reasonable, rebond him. And he'll make an explanation to the court, and so will I, as to what occurred on his non-appearance.
I appreciate that, sir. We look forward to seeing him tomorrow then.
Right. His not being in court was not due to disrespect, Your Honor. Notice went to the wrong lawyer and he wasn't notified, but we'll explain that in the morning.
Oh, okay.
The judge of that may be excused until tomorrow morning.
Yes, you and Mr. Martinez can be. We'll see you tomorrow morning.
Thank you, Judge. Have a good day.
You too. Deputy, did Mr. Washington go with the court? Oh, okay. Okay, court is going to be in recess for 1 hour. Be back at 11, please. I'll be back at 11. not a problem. Mr. Gonzalez. Unmute and respond, Mr. Gonzalez.
Yes, ma'am.
Oh, very good. Okay. I just wanted you to know that we're waiting for your attorney. He should be here shortly, okay?
Yes, ma'am.
All righty, thank you. You can go ahead and mute yourself. Attorney Donald?
I have a client here who was FTA and the warrant was going to issue today, but she's here. We are asking to reset the case for pretrial conference September 1st, and there's a referral to the mental health court. She's already signed up to see them in person this Tuesday at 1:30. I'll walk her down.
Did she sign in the back? Yep, she did. Alrighty. I want to refer her over to Bear County Reentry Center.
What's that, Judge?
Bear County Reentry Center to see what they can do for her as far as getting her into some kind of shelter or quarters. They have a program. I sent a client over, a defendant over there, a probationer, and he said they were able to work with him to get him into housing.
Great. And the mental health court will see her on Tuesday. If she's eligible, they'll do the same.
Oh, they
but
will.
It might take longer.
Okay, Bear County Reentry Center. You know where that is, right?
I believe, yeah, it's I don't know the address, but I know what it is.
What is the jail, South Comal or North Comal?
North Carolina.
Thank you. Same place where the what day, sir? For the pretrial conference hearing?
I can't remember, Judge.
What day did you have this reset to for pretrial?
September 1st. September 1st.
Do we have a reset?
Well, I could ask if it can be sent, signed right now, Judge.
Yes, sir.
Very well. Did you want to talk to my client or are we good?
We're good.
Thank you very much, Ryan.
Thank you. Attorney Strickland,
Yes, sir.
do you have a microphone or are you going to step up here? Right up here, sir.
Okay.
There's one up here, Deputy.
Okay.
I purposely put one up here, so I'll be ready. Okay. Bring your client up to this seat. Let's get on record. State, you ready to go ahead and proceed on cause number 662-936?
Yes, Judge.
Alrighty. Let us get on record on cause number 662-936, State of Texas versus Daniel Raymond McDonald. Defense, are you ready to proceed on this matter?
Yes, sir.
State, are you ready to proceed?
Yes, Judge.
we're here for state's first motion for continuance. State, it is your motion. Please proceed.
Thank you, Your Honor. Your Honor, the reason that this motion was just filed yesterday was because initially the state was hoping that we would be able to go to trial this week. Obviously, we had prior hearings regarding the discovery issue raised by defense. And as a result of the court's ruling, my understanding of it was that I wouldn't be able to call any witnesses other than those who I had notified defense of in writing by the June 22nd date, I believe it was, which would have been none. And so the effect of going to trial this week would be a forced dismissal because I would have no opportunity to present evidence. And so at this time, I'm asking the court for a continuance because if the case were to get dismissed at this point, it would not be based on the merits. It would be based on a procedural defect. And I don't believe, and I don't think it's objectively true that dismissal on a procedural defect is a just outcome for a case. And the issue raised at the discovery hearing was that defense did not have sufficient notice of the state's witnesses. As I put in my motion for continuance to the court, as soon as I realized my mistake that I had missed the timeline for providing the witness list to defense, that was last Thursday, July 7th. As soon as I realized my mistake, I immediately went and filed a witness list and served it upon the defense and moved to correct the mistake that had been made. And so while I understand the reason for the court's ruling that defense deserves their requested notice for witnesses, I would ask the court that we just delay this case, and I will defer to defense. We can have a reset for as much time as they would wish to be prepared. But I believe that since this is the first trial setting, there's been no prior continuance ever asked for in this case. And given the fact that the reason we're asking for continuance is just to correct the notice issue to defense, I think the right thing to do here and what I'm asking the court to do is to just reset this case and allow both parties to proceed to trial fully prepared.
So this motion is being proffered for purposes of delaying the trial?
Well, I'm asking for continuance. So I guess, yes, it is asking that the trial be delayed.
Defense?
Judge, we would object to any further delay. I would have been a bit more receptive to this motion had this come up maybe Thursday morning when this issue first came. This is now the fourth day in a row that Mr. McDonald, the defendant in this case, the only person who really has rights here, Judge, as far as this case goes. The fourth day in a row that he has been present in your court, either in person or via Zoom, that we have been dealing with this. And now that the state, after having that hearing, is in a spot they do not want to be in, they're now asking for a continuance. Not when the issue first rose up, but now that they're in a bad spot. Judge, this case is over a year old. It's about turned 13 months a few days ago. We are urging, as we did in writing, right around the time this case was first, when in our first filing in this case, we urged Mr. McDonald's right to a speedy trial. And so we object to any further delay, Judge. Delaying this matter, Judge, would really render everything we've been doing the past 3 days in your court meaningless. And I do not agree that a dismissal of this case would be an unjust ending for it, Judge. I think that any result of the case that is a result of following the laws of this country and of this state and of this court, Judge, is a just end for a case. And so we would again urge our right to a speedy trial and object to any further delay in this matter.
Defense, were you in receipt of the witness list in writing, a written witness list on the 7th?
Mr. Bosis sent us something on the 7th, yes, Judge.
Have you received it on the 7th?
Yes, Your Honor, July 7th.
The court is only hearing of this matter in this motion of this state's first motion for continuance. It is the first time that the court is hearing that witness list was provided on Thursday. State?
Yes, Judge. My apologies. In hindsight, I should have informed the court during last Thursday's trial announcement setting that I was filing a witness list that day. I guess my assumption was that I recognize that filing it on the 7th was too late for a trial the following week, but my hope was that if the case was continued, then the defense would have my list of witnesses and there would be no concern about notice of witnesses. And also just quickly, Your Honor, the reason I filed this motion for continuance yesterday was because initially I didn't wish to delay the trial. I wished to go to trial this week. However, we had a full discovery hearing, as I'm sure the court remembers very well. And the result of that was that I wouldn't be able to present my witnesses. And so there's no effort by the state to quickly shove in a motion for continuance at the last minute. It's just because I was trying to not delay this trial, but now I have no option but to ask for a continuance. And so that's why this is coming up right now.
But State, my concern is that on Thursday, we spent some time on this matter. Friday, we spent time on this matter, all on record. Monday, we spent time on this matter. And it was not until you filed this motion for continuance did you mention once, either one of you, that you had provided a witness list to the defense.
Well, I apologize, Your Honor. I really do. I just, I guess I thought the issue that had been raised was that the witness list hadn't been filed on June 22nd. So I didn't think it would help me out to say, well, I had, excuse me, well, I had filed it on the 7th. But I'm telling the court now because I'm saying that if we continue this case, then defense will have ample notice of the witnesses. But I see the court's point, and I apologize for not bringing it up. That was an oversight on my part.
Defense?
Our issue all along, Judge, was late notice. I mean, we receiving something on the 7th didn't change the fact that we didn't receive anything by June 22nd. I mean, I think it's understood that if the case was continued, there would then be more time for them to file something, but no continuance was asked for until now.
Um, the real logistical problem that I do face is I don't have any jurors. The limitation, it's a limitation. We were advised of that, and I am fourth in line to get jurors. So, and we're supposed to start at 12:30. So that's a real issue that I have. Just full disclosure, I just stated, I don't know if you heard me, I'm sorry, I spoke a little bit low and I have this mask on. So at this time, I'm not sure that I will get I am not sure that I will get jurors for this afternoon.
I see.
So this matter is going to, as far as the trial is concerned, it is going to be delayed because I've checked affirmatively for jurors, and I'm fourth in line to receive jurors. So we'll just need to go, we can wait to see if I get any jurors.
And if I may, Judge, I mean, do we expect that we'll have jurors in the next 14 days?
Oh, most likely I will let them know.
Because if we're talking about proceeding to trial in that time frame, we're still not going to have notice, and we're still not going to, we're going to have the same problems that we have right now.
Judge, if I may.
State.
So defense is correct, and that is the purpose of my motion is to ask the court and hopefully persuade you that this case should be reset, and with enough time, and that's what I was saying before, that I would defer to defense as far as the amount of time that they wish. I know obviously they're arguing there should be no continuance, but my argument is that there should be, and that it should be for enough time that they have notice of the state's witnesses, and so that at the next trial setting of this case, the state can proceed with its witnesses that it has notified the defense of. And like I said, that both parties will be fully prepared for trial. And so that is what I'm asking for, that this be continued with enough time that the notice requirement is fully satisfied.
Defense, have you had enough time to look and compare the list of witnesses the state provided? Do they coincide with the witnesses named in any reports?
I have not, Judge. I would need time to do that.
Defense, in light of the fact that I may not have jurors in order to be able to give you your day in court and satisfy your constitutional right to a trial at this time, defense, what would you recommend as far as a time frame so that I may make sure that we have priority for jurors?
We want the next available panel. I don't imagine the state will go along with this, Judge, but we'd be happy to waive a jury too and go straight to the bench.
That'd be something I can put you guys in a breakout room for you to be able to discuss.
Brent, I don't think you want to do that.
Well, Judge, the state would only agree to that if we'd be allowed to present witnesses.
Right. Which we would not agree to. So.
Okay, defense, check as far as the compare the witness list. It is a state, would you check and as far as the list that you received, whether it matches the list that's any witnesses in the files or reports that you have?
I'm sure that it does, Judge. I mean, I don't think that I'm sure that they are the witnesses that the state tends to call. I don't doubt that at all.
And therefore state, you would agree with the witness list that you provided. Does it include experts?
It does, right?
state you have already stated and agreed to that you will be limited only to the witnesses in the report and not experts, correct?
Are you asking just, like, no matter when we go to trial? I mean, I guess, yes, I'm okay, like, if I can agree to exclude the breath test expert if my other witnesses are allowed to appear and give testimony.
Right. I am going to go ahead and place you and the defense in a breakout room to review that witness list. And come to an agreement on the witnesses that will be allowed.
And is the court moving the trial date? Because you said we don't have a jury today, or you're pretty confident we won't have a jury today.
Right, right. I'm still holding out to see if we would have jurors today, but I'm right now, it's not looking good that we would get jurors. But it is still a sliver of hope. Just a tiny sliver of hope.
Your Honor, based on your ruling yesterday, I'm not going to agree that any witnesses can be used at trial. That, as I understood that to be your ruling, and so I like that ruling, and I want to go with that.
I understand, defense, your position. That ruling was made without the knowledge or benefit of knowing that witnesses have been provided to you.
Not timely.
Not timely provided, but they were provided on Thursday.
And it sounds, and I'm just trying to understand, Judge, it sounds like based on that late witness list, it sounds like the state may now be permitted to call those witnesses. And if that is the case, Judge, then there does need to be delay in this case so that we can prepare for trial. That is not what I want, and that's not what I'm asking for. I'm just trying to understand where we're at right now, because I felt like we walked in one place and we're in a very different place now.
Yes. Based on the motion for continuance, and we went Thursday, Friday, Monday, and it was not until I received the state's motion for continuance that I learned that a witness list was provided to you on Thursday. I ruled on Monday, just yesterday, without that knowledge. I did not get the state's motion for continuance until very late. It was filed at 4:14 p.m. It was when it was accepted yesterday. I had already did my ruling. The usual cure for lack of discovery is to make discovery happen. And so the state has provided you a list of witnesses. I don't have a problem. This will be this not ready, and continuance will be on the state. This is an opportunity I'm giving you to be selective as far as the state has already agreed that they will not call any experts. So if they have experts on that list, they will not be allowed to test, they will be denied.
then if that's the situation, Judge, that they will now be allowed to call witnesses, then I'm gonna ask for time to prepare for trial. I would like this to show as a continuance requested by the state, because that's really what's happening here. But yeah, I mean, that's just a totally different, situation.
Yes, sir.
And again, Judge, I mean, just one last time, I mean, what we have been discussing, regardless of whether a late list came in, what we've been discussing was whether it had been provided by June 22nd or not. It hadn't. This doesn't change that. We'd ask the ruling to stay the same, but I understand what you're saying as well, Your Honor. And so I certainly accept your ruling and however you see this should go.
And also you understand the court does admonish both parties to exercise due diligence to ensure that discovery does not impede the execution of trial. And discovery has impeded the execution of this trial. And so although I'm very sympathetic and I understand the defense's position regarding this, and that you have performed your due diligence in requesting for witnesses almost a year ago and still insisting on a written list for witnesses on the by the 22nd of June, excuse me, expecting that to be presented to you. The state has presented a witness list to you in writing, and it will be, I will deny their production of use of any expert witnesses. So I urge you and the state to look at that list carefully and determine who the experts will be the state has already agreed to, that will not be allowed.
I'll just go, I guess step out and we can get in the breakout room.
Okay? That's,
Thank you very much, Judge. And I can confer with defense now if they are available.
state, just so that you know, the dates on your motion, and some of this needs to be corrected. I will grant your motion for continuance limited, but thus limiting the witnesses that you may use as though upon what you and the defense agree to.
I will, I'll hop on from there.
Okay.
If Brett and I can place that breakout room, Judge.
Yes, sir. We're off record.
Last week ago,
Sir, you can approach.
last week.
Approach. Good morning, sir.
Last week, my attorney, Thomas Hill, never came, and I called him, no nothing. And today, I left him a voicemail, gave him my number, and he's still not here, and we still haven't talked about my case, and he wants to reset it for jury, and it's not really that serious, like, why he wants to reset it for jury? And
He's in touch with you to say he wants to set it for jury.
yeah, he said that, but he sent it on text, and other than that, we haven't talked about anything. Like, he haven't met me, he haven't even seen me. And he said he was gonna be on Zoom, he's not even on Zoom.
Judge, I apologize for the interruption. Could you put me in a breakout room?
Yes, I am about to do that. So, what do you want me to do?
I can't get like another attorney.
Let me take a look at your case. sir.
Okay.
You guys haven't talked at all about
No,
it.
we haven't, not even one word, nothing, not even a phone call, he reached out to me, nothing.
Pinada, right? Pinada? Pinada?
Yes,
Pinada, Romero, right?
yes.
Go ahead and have a seat, okay, sir? I'll make sure that you're able to we'll get someone to tend to you, okay? All right, thank you. Mr. Pinella? When were you here last? State, is defense coming out?
Yes, Judge, he said he was gonna be coming back to the courtroom, so.
Okay. Okay. I'll be back in a couple of minutes. Thank you. State? State, can you hear me?
Yes, Judge.
Yes, I think that was the only case that we had for potential trial this week, correct?
Yes, Judge, that was it.
Okay, all righty, thank you. Because we did get jurors. There's jurors available, so let me release them. Okay?
Okay. Is defense coming back or?
Yes, he's coming back. He's trying to get a date. He's talking with the court coordinator to get a date for you guys to agree on, okay? And I'm
Okay.
thinking that a Rule 11 would be appropriate in this case as well, okay?
Okay. You'll have to educate me on what a Rule 11 is.
Oh, okay.
Doesn't that come
An
from civil law?
written agreement.
Okay.
Okay, the matter that we have to deal with, I don't know, do we have the interpreter yet? Doesn't look like it. Okay, Attorney Kretschmar,
Yes, Your Honor.
okay, did you look at the paperwork, the Spanish version, and did you see the discrepancy?
Yes, I did. I believe that the charge on the Spanish paperwork was incorrect, so I just manually whited out and included the correct charge. And I've scanned it back to Miss Luna.
Okay, let me see if she.
Judge, I gave you the printed copies to you.
You need to
Want-
send it to me. Send it
You
to
want me
me.
to forward that
email.
email to you?
Yes, please. Thank you. Alrighty, so counsel, on the McDonald case, I have signed the motion for continuance, and I have noted on the motion for continuance that a Rule 11 will be forthcoming from you, between you and the state. List of witnesses limited to a Rule 11 agreement.
Absolutely, Judge.
Okay.
And then, this Monday is the date of July 25th.
July 25th, state.
No objection to that, Judge.
If there are any developments, Judge, we're going to
Okay. That's the trial date. I will expect you back on the 21st for a trial announcement.
Perfect.
Okay,
Thank you, Judge.
alrighty. Does he have a reset form?
Marina's gonna email it.
Then yes, you can be excused. Mr. McDonald, thank you so much for coming.
Judge, can I go ahead and dismiss the jurors then?
Yes, we can release the jurors. Ooh, no, they're not coming. We're not gonna use them. today. So some days we're very lucky with regard to jurors available, interpreter availability. And some days is really busy. So beg your patience, Ms. Kretschmeyer, Attorney Kretschmeyer, and we are still waiting for the interpreter, but your client is still not connecting to audio, just so that you know, okay?
Oh, thank you for letting me know, Your Honor. I'll go fix that. I was waiting for the interpreter to log on so I can enable his interpretation function. So when that happens, I'll make sure to turn on his audio as well.
Very good, thank you.
Thank you.
Ms. Ana Marie Garcia, your attorney and Mr. Gonzalez, I know you both have the same attorney. He's delayed. I know that he has, he does expect to be here, but he probably will not be here till the afternoon. Okay, I mean, it's looking that way. So after I take this plea, Mr. Gonzalez, we need to make arrangements to make sure that you are able to log back in around about 1:30.
Yes, ma'am.
Okay, all right,
Yes, ma'am.
very good. Ms. Garcia and Mr. Gonzalez, your attorney just made contact with the court and he should be back in 10 minutes, okay? And he wants to talk to both of you.
Yes, ma'am.
So just hang tight. Good morning, Attorney Gonzalez. How can I help you?
Good morning, Judge. I have a case that's not on your docket today that I need to discuss. So, I mean, if you'd like for me to wait or if I can come back, or I just don't know how to approach you on a case that's not on docket.
Basically, I think that you're doing just fine. Do you need to talk to the ADA?
I need to talk. I believe I need to talk to you, Your Honor.
Okay. Alrighty. Do you have a case number?
Yes, ma'am.
Go ahead.
Case number 672056.
670. I'm sorry. Say again.
Yes, that's fine. 672056.
Thank you.
You're welcome.
And what's the defendant's name?
Gilbert Rosas.
Okay. Do you have the court's number? They just need to pull that case for me.
I'm sorry. Are you talking? Do I have the
Yes,
court?
yes, could you call the court and have them pull that case for me and bring me the file? And I'll be able
Yes,
to talk
ma'am.
with you. Okay, thanks.
Okay, let me call them really quick.
Attorney Gonzalez, I have the file. Please proceed.
Okay, yes. Yes, Judge. So I'm going to e-file the jury waiver because I have talked to an ADA. There was an offer made. I actually had this plea. I'm not certain why I'm on the jury docket, but that's not the point. He now has a warrant for his arrest on violations. but at the time I was speaking with the ADA at the time, we were making arrangements for his plea deal because he does not own a vehicle. So what I am here for is to find out if I need to file a motion and ask for his warrant to be recalled. I have tried several times to speak with his pretrial officer. I did tell her, so finally she called me back today. And if we can get the warrant recalled and I can get the waiver over to her and a motion for a different device, that she's willing to work with us on that. And I don't know how you feel about that, but he works on an ambulance. And then she told me I also needed orders to specify, like just during a certain amount of time, that he can't take the mobile device on an ambulance. It really, it's not like it's a lengthy schedule. Again, we showed up to court and probation said they would work with us. They just haven't thus far.
Well, yeah, this is his second violation for non-enrollment. And I had set for a performance review on the 26th. That's when I signed it, asking for there to be a performance review so that we could talk about his non-enrollment and what he needed to do to cure that. So what he needs is affidavits that he does not own a vehicle, the vehicle, and then he needs to provide a status in that affidavit of non-ownership. He needs to tell us what happened with the vehicle that was involved in the incident, because obviously there's a vehicle.
Well, no, it was his mother. It was his mother's vehicle. He's never had, well, not never. He didn't have a vehicle at the time of the accident either. He drove his mother's vehicle, and you know, she doesn't allow him to drive her vehicle anymore, which I can understand.
Sure. So put that all on the affidavit. Who owned the vehicle? Describe the vehicle by ignition, by a year, make, model, color.
Okay.
The license plate number and the last 6 digits of the VIN number, and the relationship that he has with the vehicle owner. And if he does live with his mother, it's going to be very complicated because he does have access to that vehicle. And so it may have to order an ignition interlock, but let's talk about that. Okay, before we do that, before I do that, let you and I, let's talk about it in a performance review, okay? So we can delve into more of what's going on. Regarding so that's the vehicle affidavit of non-ownership.
Okay.
Then he needs to do an affidavit, and it can be in the same one.
Okay.
That he will not drive a vehicle that's not equipped with an ignition interlock.
A vehicle that does not have the ignition interlock on it. He will not drive one that does not, yes. Your Honor, you said that you had a status review on the 26th.
I ordered it
this
on
month?
For the 26th of March. That's when I ordered it. I don't see any indication that it was actually scheduled and heard. And then he got a second violation. So.
Okay.
For the same thing, non-enrollment.
Okay, so I'll file my motion, and when can we talk about, I guess you'll reply back to the motion that I file.
You don't need to go ahead. I mean, if you wish to go ahead and file a motion, that's not a problem. But I need the affidavits and non-ownership and the fact that he will not drive with a vehicle not equipped with an ignition interlock. Then, then
should I email that to the court?
Yeah, e-file it. You can e-file it.
Oh, e-file it, okay.
Yes, and we'll get a copy to pretrial. And you
Okay.
might want to go ahead and talk to pretrial because they do have some more specific information that they need on that affidavit. You might want to talk to them first and say, what other information do I need on an affidavit? With
Okay.
that, pretrial will come to me and say, okay, he's filed this affidavit. Can he put on a portable alcohol monitoring device? And I usually approve it from there. Okay, I act on their motion,
Okay.
their document. Now, as far as the warrant is concerned, you need to present him in person.
I'm
me to-
sorry.
As far as the
internet
warrant,
did something. Yes?
yeah, as far as the warrant is concerned, if he doesn't want to go ahead and go through as far as that warrant, he needs to come in person for us to talk about the warrant. He needs to, so you need to present him in person.
Okay. And what day can he come in there? Today, tomorrow, on a day off? How soon can we get him in there?
You can get him in here this afternoon.
Okay, thank you, Judge.
And
I'll
if
see
not,
if he,
tomorrow's fine too, if that works better for you. This afternoon or tomorrow.
okay, I'll have, okay, then may I show up via Zoom while he's in court, please?
Yes. Yes, you can.
Okay,
We're
perfect.
hybrid.
Okay.
We're hybrid.
Okay, thank you, Judge, so we'll see you later today or tomorrow.
Okay,
Okay, thank you so much.
not a problem. Okay, it looks like, okay, there you are. Attorney Stetson, whom do you wish to speak with first?
Elijah Gonzalez, please.
Attorney Kretschmeyer, we're going to find out what's happening with the interpreters.
Yes, Your Honor.
We're gonna see what's going on with the interpreters. So we'll go ahead and come back at 1:30. Sorry for the delay. Yeah, so we'll see. Is 1:30 not working for you at council?
Well, I am scheduled to prove up some cases at presiding court at 2. I have a client coming in. But I guess the schedule there is a little more flexible.
Why don't
But yeah,
I go ahead?
I do have clients coming into the office in the afternoon.
Sure, got it. Why don't I put you in with Ms. Luna, the court coordinator, and let's see when you
Okay.
can go ahead and come back, okay?
Okay, thank you.
All righty, not a problem. And then we'll make sure that the paperwork and everything is all done.
Okay, thank you, Your Honor.
All righty.
Señora Miriam,
Do you want me to put your client in there with you? State, we're going to go ahead and take a break for lunch now. We'll resume at 1:30, okay, State?
Okay, Judge, I'll be back at 1:30.
Thank you very much. All righty. And CLO Jennings, I've got some of the paperwork. Let me work on that and then I'll see you back at 1:30. CLO Jennings?
Yes.
And yeah, see you at 1:30, okay?
Okay, thank you.
All righty, thank you.
You're welcome. Oh shit, it's bright in here.
Okay, I'll get you. Ready. Okay. CSR Delgado, 1:30. Ms. Ana Marie Garcia, you just hang tight. Your attorney wants to talk with you, okay?
Yes, ma'am.
All righty. So as soon as he's done with the other one, I'll put you in with him, okay?
Yes, ma'am.
Deputy, that will do it till 1:30, okay, sir?
Okay, ma'am.
All righty, thanks.
Judge, the interpreter just logged in.
Oh, Senora Nero, good afternoon.
Hello, Judge. Good afternoon.
Yeah, I am so sorry. I had let everybody go for lunch already. Is there any way that we could get you back at 1:30?
Yes, Judge, of course. And I apologize. We were all busy and I just got back from another court. That's the reason why,
Oh,
I just became available. Everybody else is busy.
I know. No apologies needed whatsoever. Understand. Like I said, sometimes we're lucky. We get somebody right away and and sometimes it's just, you guys are very, very
Yeah.
valuable, provide a valuable service.
Thank you, Judge.
Miss-
We try to be there for everybody, but sometimes it's just like not enough of us. But you want us at 1:30?
Well, let me double check. Marina, what did Attorney Kretschmar say? What did you guys discuss? Marina? Miss Luna?
Yes, Judge?
What did you guys discuss? Did you guys reset the case?
Yeah, we're gonna reset it for a week until next, the 19th. So I'll go ahead and put the request for the interpreter for that day.
Alrighty. So,
Okay.
So it'd be the 19th.
Okay, so you just will resend the request, right, Marina?
Yes,
Okay.
ma'am.
All right, okay, and my apologies again, Judge.
None
Okay.
needed. Thank you very much.
My pleasure, okay? See you next time.
Okay. Oh, did you need me to sign it?
No.
Attorney Stetson?
Yes, Judge. I know,
Okay. Go ahead.
I know it may be lunchtime for y'all. I don't know if you're still going through it, but we signed paperwork. Elijah Gonzalez is ready for a plea.
Great. Can we do that at 1:30?
I will come back at 1:30. Let me double check something because there is a mediation CPS. I may be here a little late, but I will be here. Yes.
Okay, and now you want to talk to Ms. Garcia?
In a breakout room, and I will return for her case also at 1:30 afterwards, correct?
Yes, sir. You'll let
Yes.
me know at that time
Yes.
whether we're going to go through with it or not, or you going to come back and let me know?
Yes, Judge. I'll let you know if it's a plea or trial.
Yes, okay, great. Let me put you in a breakout room with her.
Thank you, Judge. And Mr. Gonzalez, don't tell the deputies to take you away. You still have to come back at 1:30.
Sorry, Attorney Stetson?
Hello, Judge. Ms. Garcia has indicated that she has either hired or is about to hire another attorney, Carolyn Whitland. Monica Guerrero is appointed, and Ms. Garcia is choosing to have an attorney of her own choice. I don't know if she hired someone yet, but would you permit her time to hire Carolyn Whitland?
Okay, thank you. Ms. Garcia, how far away are we from doing that? Because
You're on mute. Anna, you're on mute. Unmute yourself. You're on mute.
Okay, Your Honor, Ms. Whitland was out of town. She just returned. I've spoken with her today via text and email. So she's in court and taking care of other things today, but we will be meeting in the next couple of days, and she is aware of, she has my case number and stuff, and she's going to do the best of her ability with your permission, Your Honor, to help me.
And Anna, have you hired her? That's what the judge is asking, or do you
Yes,
need 2
yes.
weeks? You already hired her. You paid
No,
her?
I haven't given her no money because she hasn't given me a price yet.
So
but I have
you
done her
need,
actual
you
communication.
need 3 weeks to hire her then.
Yes, sir. Yes, sir.
Why 3 weeks?
It's my understanding, Miss Whitland, she was out of town for a little while. I don't know what, but I just let her know about my case.
Why
called
do you
her.
need 3 weeks to hire her?
I don't need 3 weeks. I
Well,
mean,
So how
I can-
much time do you need?
waiting for her to let me know. But she told me to talk to you guys first, and when you authorize that I can hire her, then she told me to call her office so that we can set something up ASAP. Ma'am, Your Honor.
Okay, so
Her
how
ex-
much time do you need to hire her?
A week? Probably under.
Alrighty, okay. I'm gonna
She's-
give you 2 weeks.
Thank you,
You
ma'am.
need to put in, I'm gonna give you 2 weeks.
Yes, ma'am.
Okay.
Thank you, Judge.
So, but hang on 2 seconds. I'm gonna
Yes, ma'am.
put you in the breakout room with my court coordinator. So she has all your information. And then and then from there, we're looking at 2 weeks.
I'm at the court
Yeah.
system, Your Honor. Anything you said.
Let's look at you. Coming back on the 1st of August.
Yes, ma'am. Yes, ma'am.
Wow, time's traveling real fast.
Yes, ma'am, it is.
Okay, so I'll put you in the breakout room with the court coordinator and 1st of August, okay?
Okay, thank you, Mr. Statesman. Thank you, Your Honor. Thank you, court.
You're welcome, Anna. And Judge, I will return at 1:30 or so for Elijah Gonzalez, all right?
Yes, sir.
Thank you, Judge.
I want you to be aware of that, because I don't want you to think, okay.
Okay, Ms. Garcia, if you're all set with your reset form,
Yes, ma'am.
okay, have a good day. See you on the 1st of August.
You as well. Be blessed, ma'am. Thank you.
You too. Bye-bye.
Bye-bye.
Okay. Say again?
Did you have a good lunch?
Oh, I ended up talking to my sister the whole time. I should have known better than to return her phone call at this time. I needed to make other phone calls. That did not work out.
Mine tried calling too, I did not.
Okay, Mr. Gonzalez, thank you so much for being here. Just waiting for the attorneys to show up. Okay, Mr. Gonzalez?
Yes, ma'am.
Okay. All right. Thank you for your patience. ADA BOSIS, we're waiting on Stetson. Oh, he's logging in right now. Let's let him in. Okay, Attorney Stetson, just in time. So are we ready to go ahead and plea on Mr. Gonzalez? Attorney Stetson, can you hear me?
Oh, I had it on mute. I'm sorry. Yes, I'm ready. Did you receive the signed, Mr. Gonzalez signed it. Did you have the signed copy of it?
Yes, I have the documents.
Yes, we're ready.
I have the paperwork. Okay. Let's get on record on cause number 646030, State of Texas versus Elijah Gonzalez. Parties, please approach and identify who's before the court, starting with the state.
Brett Bosis for the state.
Joseph Stateson for defendant.
And are you Elijah Gonzalez?
Yes, ma'am.
Are you the same Elijah Gonzalez that's accused of evading arrest or detention and alleged to have occurred on the 3rd day of September 2020 and is classified as a Class A misdemeanor? Are you the same so accused?
Yes, ma'am.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth under pains and penalties of perjury, so help you God?
Yes, ma'am.
Thank you. You may go ahead and lower your hand. Court is going to start sharing the court screen. And for the record, all parties are via Zoom. I'm making the appearance via Zoom. Mr. Gonzalez, can you see the court screen?
Yes, ma'am.
And counsel, can you see the court screen? Mr. Gonzalez, I'm going to mute you in between, okay? So remember to unmute yourself. But there's noise coming from your background. Counsel, can you see the court screen?
Yes.
And the state?
Yes, I can, Judge.
State, on display is a document entitled State's Consent to Video Conferencing. Did you sign this document that's consenting to these proceedings by video conferencing?
I did.
State's video conferencing consent is made part of the record. Defense, displays a document entitled Defendant's Consent to Video Conferencing. Mr. Gonzalez, is this your signature where I am circling the cursor?
Yes, ma'am.
And did you sign this document that's consenting to plea by video conferencing?
Yes, ma'am.
Counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
Yes, Your Honor.
Defendant's video conferencing consent is made part of the record. Counsel, how long have you represented Mr. Gonzalez?
Well over 30 days, Your Honor.
And are we applying for probation? And if so, what type?
No, this would be a jail sentence.
And thank you, State. And State, have you fulfilled your Brady and discovery requirement in this case?
Yes, we have, Judge.
Counsel, with your, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as giving you full access to the state's file and state's file?
Yes, Your Honor, I'm satisfied.
State, is this matter subject to law enforcement disclosure? And if it is, has that been fulfilled?
Judge, this case is not subject to that.
Okay. Thank you, State. I will sign the discovery acknowledgement, making it part of the record. State, any motions for the court's consideration?
No motions from the state, Judge.
Defense, any motions for the court's consideration?
No, Your Honor.
Mr. Gonzalez, I draw your attention to the document entitled Defendant's Waiver of Constitutional Rights and Course Admonitions. This is a 2-page document. This is the first page, and then this is the second page. Mr. Gonzalez, is that your signature where I'm circling the cursor? Right here?
Yes, ma'am.
And did you go over this document with your attorney?
Yes, ma'am.
And after going over it with your attorney, did you freely and voluntarily sign it?
Yes, ma'am.
So with your signature and testimony at this time, you're telling me that you understand everything in that 2-page document as it was reviewed and explained to you by your attorney.
Yes, ma'am.
And are you satisfied with the representation of your attorney?
Yes, ma'am.
And you understand the range of punishment in this case,
Yes, ma'am.
as well as your constitutional rights?
Yes, ma'am.
And do you freely and voluntarily give up your constitutional rights as you understand them?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
I will approve your jury waiver, and I am going to sign it, and you will no longer have a trial in this case. Counsel, do you believe that your client is competent to enter into a plea today? Counsel?
I'm sorry, I had background noise distraction. Would you repeat the question?
Do you believe that your client is competent to enter into a plea today?
Yes, Your Honor.
And with the information, we're able to apprise this defendant of the nature of the offense and the charges against him?
Yes, Your Honor.
And do you and this defendant waive the formal reading of the information?
Yes, we waive it.
State, what is your punishment recommendation?
Judge, the state recommends pardon me one moment, I lost my place here.
Yeah.
Judge, the state is recommending 30 days in the Bexar County Jail with a $500 fine plus court costs. Defendant will get credit for time served. He has served a little over 30 days, I believe. The time and money will run concurrently. And at the conclusion of this plea, the state will reject an unfiled case. The JN number on that case is 2038319.
And what was the offense?
Criminal mischief.
Deputy, would you be able to check, do you have the SID number?
No, ma'am.
It's 113-9150. Number of days in jail. Counsel, is that your understanding of the state's punishment recommendation?
It is, Your Honor.
Mr. Gonzalez, is that your understanding of the punishment recommendation of what your attorney has worked out with the state on your behalf in order to resolve this case for you today?
Yes, ma'am.
With that understanding, how do you wish to plead? Guilty, not guilty, or no contest?
Guilty.
Judge Elijah, I had advised him to say no contest.
Oh, no contest.
Okay, so you meant to say no contest, sir?
Yes, ma'am. I forgot.
No, that's not no problem. So now do you understand that even though you're pleading no contest, I can still find you guilty?
Yes, ma'am.
And you still wish to proceed?
Yes, ma'am.
Okay, now, after you've talked with your attorney about all this, you're telling me with your plea of no contest that you don't want to fight all the charges in this case?
Yes, ma'am.
And after talking with your attorney, you're telling me that with your plea of no contest, you believe that's in your best interest?
Yes, ma'am.
Okay, I will accept your plea of no contest, finding that it's intelligently made and freely made and that you're competent to do so. Counsel, anything on behalf of your client, if anything, and why should I accept this plea?
Judge, my client does not contest the charge. He has over 30 days in jail. He's been booked. He's unable to post bond, and this would resolve his other case that they're about to file. He wishes for you to follow the plea deal so that he could have time served and be released.
He was arrested on 6/16.
Okay. He had some days from his prior arrest on this case, right?
I believe he's been booked since June 11th.
All right. Okay, and probably giving him time. All right. Counsel, is there any legal reason why this why sentencing cannot be imposed today?
No, Your Honor.
Okay, thanks. Mr. Gonzalez, I'm going to find you guilty and I'm going to sentence you to 30 days in Bexar County Jail plus $500 and $500 fine plus court costs. You'll get credit for all the time that you've served. Your time and money will run together. The state will, in turn for this plea, will go ahead and reject JN 2038319 for a unfiled case regarding criminal mischief. And I will find that you have served 30 days or more in Bexar County Jail and will satisfy this judgment.
Yes, ma'am. Thank you.
All righty. So we'll go ahead and get you taken care of so that you will be able to, we can get you out of there. State, did I cover everything for you?
Yes, you did, Your Honor.
And counsel, is there anything further?
No, Your Honor, that covered everything. Thank you.
Alrighty. Mr. Gonzalez, regarding the trial court certification of defendant's right to appeal, this has been a pre-bargain case, and I am going to certify that you have no right to appeal, okay?
Sure.
I have signed it, made a copy of it, and sir, when you do get out, within the next, by Friday, how about by Friday, you come by and we'll get your fingerprints on the court file, okay?
Yes, ma'am.
Alrighty, I appreciate you hanging in there with us today and your
You're welcome.
patience. Alrighty, okay, I wish you the best. And sir, you might want to check out Bear County Reentry Services is down the road from where you are. It's at 222 North Comal, and see what they'll be able to go ahead and help you out with, okay?
Yes, ma'am.
All righty, thank you again, and I wish you the best.
Thank you, ma'am.
All righty. Counsel, there being nothing else, do you have anything else in this court?
No, that's everything. Thank you, Judge. May I be excused?
Yes, you and your client are excused. You're done, Mr. Gonzalez, okay?
Yes, ma'am. Thank you.
Thank you. Have a good one.
Too.
Okay. State, I think that takes care of it today for us. State, when will you and Mr. Attorney Strickland get me that Rule 11? Do you guys think you can get it to me by Friday?
Yes, I think that will be doable, Judge.
Okay, thank you very much. I appreciate it. Please, again, thank you for coming back and forth, and you have a good rest of the day, sir.
Thank you, Judge. And just quickly, the plea for David Sanchez Cruz, has that been reset to another day?
Yes, sir. I believe it was reset to the 19th, just so that I think the attorney had some conflicts coming up. So it was
Okay.
just best to go ahead and reset it and double check the paperwork and all that.
Okay. Thank you, Judge. Have a good
Thank
evening.
You too, sir. Thank you. Hey, folks, just give me 2 seconds. I just need to go ahead and finish up the paperwork so we can get somebody processed and out of jail, okay? So just give me a couple minutes, all right? Thank you so much. Okay, so we have good afternoon all. So we have for pretrial, we have cause number, okay, Santiago Nieves, Santiago Nieves. And Miguel Arvalo, Miguel.
Here, Your Honor.
Oh, very good, thank you. And who is here for Mr. Miguel Alvaro?
I am, Your Honor, CSO Charity Keeling.
Okay. Alrighty, and then I have Jocelyn Yarley Alvarado.
The Broncos is only open on Wednesday through Saturday. And they open at
Jocelyn Yarley Alvarado, could you please unmute and respond?
I'm here, Your Honor.
Okay, very good. And who is here for Ms. Jocelyn? Is that you, CSO Hart?
Yes, good afternoon. Supervision Officer for Jocelyn Yareli Alvarado.
Okay. Miguel Alvarado, I'm going to put you in the breakout room with the deputy.
Okay.
Let's go ahead and get on record on on cause number 672-537, State of Texas versus Jocelyn Yarley Alvarado. Parties, please approach and identify who's before the court, starting with the CLO.
Ashley Jennings, Court Liaison Officer for County Court at Law Number 2.
CSO.
Supervision Officer for Jocelyn Yareli Alvarado, Jessica Hart.
Very good. Thank you very much. And you are Jocelyn Yarley Alvarado?
Yes, Your Honor.
Very good. Keep your arm uncrossed just like that, okay? All
Yes, ma'am.
right. So, and sit up. I like that yellow jacket. It's very nice.
Thank you. I appreciate it.
Good. CLO, when was the last time that we had a court visit with Ms. Alvarado?
Yes, Your Honor. The last court appearance was when Alvarado was granted deferred adjudication for 12 months for obstructive highway. Your Honor, you asked for a hearing for a status update, This case is set to expire May 23rd, 2023.
Mhm. Okay, when was she granted?
He was granted May 24th, 2022.
Mhm. So, CSO, how has Ms. Alvarado been doing while on probation?
Ms. Alvarado was granted probation on the 24th of May for obstruction highway passageway. She does not have any prior MTRs. She did submit a diluted drug test on July 1st, and the specimen was too dilute to assure a valid negative result. I spoke to Ms. Alvarado and she stated that she drinks a lot of water, especially in the morning. She attends the gym and she was instructed to lower her water intake. She reports full-time employment with DMCA, earning 17 an hour. She has completed a TAP evaluation on, she is scheduled to attend a TAP evaluation on the 1st of August. She completed U-Impact class on April 30th, BWI education on May 2nd. And she installed the ignition interlock on the 27th of May as a 6-month requirement. She hasn't had any violations and she will be eligible for removal in November 26, 2022. She was given 60 hours of community service restitution. She was credited 24 hours for the COVID vaccine. And she plans to finish the remaining 36 hours with the Blessed Angels Community Center. Her financial obligation of $1,307 was paid in full and restitution was not ordered.
Okay, who granted 24 hours for the vaccine?
So the court guidelines say that she could only be credited 10 hours for the vaccine. But on June 10th, 2022, there was a signed motion by her lawyer to amend conditions to include 24-hour credit for the vaccine and 5 hours for the booster, which is still pending.
Okay. Okay. I think she was granted that by the judge who was substituting for me.
Okay.
Okay, so we're here on, why are we here, CLO? Where's this, where is the SR? Because we're here because of an SR, right? A supplemental review.
Let me check, Your Honor. No, you requested for this hearing.
Right. Could you provide me the SR, please? Majority of the hearings I request for.
There was no SR. I received an email from Luna stating that you wanted to set this up for a hearing.
When was it diluted? When did that dilute occur? At CSO?
The test was on the 1st of July.
Do you give folks instructions regarding the diluted, how to prevent dilution? Do they get that when they're,
I'm not sure if they are provided actual instructions by Recovery Monitor Solutions. What we can do on, what I can do on my end is let the probationer know that to lower the water intake.
well, did you, when they go through orientation, are they told when to stop drinking or giving instructions on how to prevent dilution? Do you understand my question? Are there any instructions given to probationers, or do you give any specific instructions? Do they get it at orientation, how to prevent dilution?
I'm not sure if during the initial interview, they are provided with that information. That's provided by some, the intake team. But I did tell her not to drink too much water. She shared that she drinks a lot of water in the morning, and although it's a healthy habit, she would have to lower her water intake to avoid any more diluted tests.
CLO, what is the instructions normally given regarding to methods to prevent dilution?
From my understanding with intake,
What does intake provide that? Does orientation provide that instruction? And what is the instruction?
for the diluted, I'm not
prevent-
sure if, go ahead.
To prevent dilution, yes.
I'm not too sure if intake does go over that, but I know for sure they go over their conditions, but I'm not too sure about the diluted UAs. Usually the CSOs go over that once they come out diluted.
Okay, so what is the instruction? What is the instruction to prevent dilution?
Yes, usually if it comes out diluted, we usually go over the dilution with the probationer and let them know that they cannot drink before going to go submit to a UA. And it's a warning. And next time is usually set for a positive UA. So we usually tell them not to drink prior to the going to go submit to a UA.
So is it not to drink at all, or to stop drinking, or how much to drink by a certain period of time?
Usually not to drink an hour before going to go submit.
Okay. So maybe an hour before that, going to submit, drink about 8 ounces or so, and then stop, because that will take about an hour to run through your body, and you'll have, but it won't be diluted, correct?
Correct.
Okay, so that's a standard instruction on how to prevent dilution?
Yes, Your Honor.
And that's not provided at during orientation. It's just that's left up to the CSO to go ahead and provide that information?
I'm not too sure if intake during orientation, if they do explain that to them, but usually the CSO does go over the dilution with the probationer.
Okay. Okay. And your attorney was supposed to be here, Ms. Alvarado. I wanted to talk to you about your travel. You, he had filed a motion regarding permission to travel. Do you have that motion? Do you have that order, Ms. Hart? On the travel for Ms.
Yeah.
Alvarado?
Yes, I do. I had her sign the conditions on June 10th.
Okay. And how are we traveling back and forth? How is that travel going to occur back and forth? Because here we're talking about going to visit county twice a month.
She has, so far she has requested one travel permit and she went on June 20th, June 18th and came back on June 20th. And she is using her personal vehicle. And she provided the information for that vehicle.
Okay. And the vehicle is equipped with ignition interlock?
Yes, Your Honor, it is.
Okay. And how many, how are we doing with, as far as the engine start? Are we having sufficient engine starts?
In the last report covering May 27th through June 20th, she had 89 engine starts.
Is that an average? How does that relate as far as the average?
I instruct them to test, to start the engine at least twice a day. So that would equal to at least 60 for the month.
Okay, alrighty. So we have no issues with regard to that?
No, she doesn't have any issues. The last report didn't have any violations. She only had 9 improper blows. But that's usually how the reports look when they first get the device. They need to learn how to use it properly.
Okay. And with providing you notice as far as the travel is concerned, did you, how did she provide you that, by email or?
Yes, I instructed her that even though it was already approved, I would still need to know where she's going and the dates. So I sent her through email a travel permit request form. And she has to fill it out and send that back to me. Once I review it, I would type out the travel permit and send it back to her to sign.
And she's providing that to you in a sufficient, in a timely manner, or when do you request it? When do you require for her to provide that to you? Within 48 hours of travel, or?
I asked her to do it at least a week before she leaves Bexar County.
Okay. So you have a permit request form, travel permit request form.
Yes, I do. That's the one. It's a Word document for them to fill out, and then she would send that back to me. And then I would make the official document.
Alrighty, very good. Okay, that's what I wanted to make sure to go over as far as requesting this was regarding the travel from the motion, because it was one that indicated as constant. I see that you are on top of it, and that works for me. Okay? All righty. Well, thank you, Ms. Jocelyn. You're doing, Ms. Alvarado, you're doing very well on your probation. Keep up the good work, okay?
Thank you, Your Honor.
All righty. You'll be surely to go ahead and complete very successfully. We look forward to that.
Of course, Your Honor.
Thank you. All righty.
Thank you.
Anything, do you have anything else? CSO Hart?
There's nothing else, Your Honor.
All righty. You're excused, and so are you, Ms. Alvarado. Thank you for your time.
Thank you.
Thank you, Your Honor.
Alrighty, let's get on record on cause number 661791, State of Texas versus Miguel Angel Arvelo.
Arevalo.
Thank you, Arevalo. I think there's in what I'm seeing, the letter is missing. Alrighty, let's go ahead and get on. Parties, please approach and identify who's before the court, starting with the state, with the CLO.
Ashley Jennings, Court Liaison Officer for County Court at Law Number 2.
CSO?
Charity Keeling, Community Supervision Officer for Mr. Miguel Arevalo.
Okay. And are you Miguel Arevalo?
Yes, ma'am, I am.
Thank you very much. I appreciate that correction. And thank you for being here. CLO, when was the last court visit for Mr. Arevalo?
Yes, Your Honor. The last court appearance was when Mr. Arevalo was granted deferred adjudication for 1 year for obstructive highway on February 5th, 2022. An SR was returned on May 20th, 2022. The probationer has had 24 days of no BRAC testing. Probationer is also not compliant with drug testing. This case expires February 4th, 2023.
You said that he has had 12 days of what? Or
it was 24 days of no BRAC testing.
yeah, so how has Mr. Arevalo been doing since placed on probation?
So as Ms. Jennings said, we've had some violations with his ignition interlock. Since his installation with his ignition interlock on February 15th to June 15th of 2022, he's had 24 days of no BRAC testing. When he was asked about the excessive amount of days of no BRAC testing, he said it was due to his employment. He stated that he normally carpools to work and sometimes does not return home to his vehicle the same day.
I'm sorry, it's because of what?
His ignition interlock, he's had 24 days of no BRAC testing, from his installation on February 15th to June 15th of 2022, meaning he's went 24 days without submitting a breath sample.
Sure, I mean, but the reason why?
He stated it was because of his employment. He stated that he carpools to work most times, and he sometimes does not return back home to his vehicle the same day.
Okay. Okay, please continue.
I spoke to him about biweekly drug testing, but Mr. Revelo did not want to sign his condition, stating that it would also cause problems with his employment because he would have to request time off. That is whenever the court set for the performance review hearing. I do want to make note that as of June 20th of 2022, he has obtained a different employment, one that is within Bexar County and does allow him to travel to and from work every single day. For his drug testing, he is also non-compliant. He has submitted three failure to submits, one from April 15th of 2022, another from April 21st of 2022, and another from June 14th of 2022. From the failure to submits from April 15th and April 21st, he did inform me on May 4th that he had the wrong dates written down and was not able to access his email for the drug testing directive. He does have one negative drug test from April 28th, 2022. He did go and submit on June 29th of 2022 and also July 5th of 2022. However, we have not received the results yet. They are still pending.
Really?
Yes, unfortunately. He goes to Treatment Associates, and unfortunately, they do take a little longer than Recovery Monitoring System to post the results. For his employment, he does report new employment at ACES, earning $23 an hour as of June 20th of 2022. For his conditions, he has submitted affidavits of non-driving family and self. He has also completed a TAP evaluation. No treatment was recommended, and he completed his parenting class. He is still pending the U Impact class in DWI education. He was also ordered 40 hours of community service that he is still pending. In regards to his fees, he's paid $124 and is delinquent $508. And so mainly the non-compliance that we're having is from the ignition interlock and the drug testing. Our recommendation is to amend conditions to include biweekly drug testing for 60 days and then monthly thereafter, and extend the duration of the ignition interlock for 3 months.
Mr. Revelo, what do you think about that?
I mean, I offered whenever she spoke to me about my missing of the breath, and also for me not following the rules for the drug test. I told her that, well, whenever she offered me that, I told her no because of my job. But now that I have another job, a different job where I'm actually able to be home every day and, do what I have to do. I told her if that was another thing that we can go back on, I would agree to that. And then when I did get on my breathalyzer monitor, I was working in the oil field, and I would drive to the yard in Pleasanton, park my car there, and we would leave in company trucks to location. And sometimes we'd be gone 2-3 days out at once. So it caused me to miss those many days. So that's why I left the company as well and said, and I've been doing my 3 breaths ever since I left that company. It caused me a lot of days that I missed because of that.
Okay. So that was from the 15th of February. And that's because of that, CSO, you wish to go ahead and extend about 3 months on the ignition interlock?
Yes, Your
That's
Honor.
the condition. But we have a new employment now, and we've been doing
Yes.
good as far as the ignition interlock blowing into it, no issues, huh?
So I did contact Lifesaver because the last calibration that he had was from June 15th. So I did contact Lifesaver to see if I can get his reports a couple of days early, just so I can monitor how he's been doing since he has gotten the new employment. But they said that they were unable to generate the report before the calibration because I'm assuming he has to have his device in there in order for the report to be generated. So I'm unable to attest to how he's done from his new employment to now. I will be getting his results or his reports on the 15th of this month, as that's his next calibration.
Tomorrow is when I have my calibration on the 13th at 4:30.
Okay, well, Lifesaver informed me of the 15th, but if you have it tomorrow, I'll go ahead and confirm.
Yeah, I have my calibration at 4:30 tomorrow.
Okay. Thank you.
Okay, so I guess Lifesaver is not real time, huh?
Yes, usually I can get the report generated a couple of days early, but unfortunately with Lifesaver, they told me they weren't able to, that they would only be able to generate his report whenever he goes in for the calibration.
Okay. Mr. Arevalo, what about these failures to submit?
The UAs?
Yes.
Like I did tell my probation officer, when I was out there in the oil field, for one, she is aware of this. I had no access to my email. My old email actually fell off my phone when I broke my phone. I wasn't able to log back in. So I did therefore make a new email, which she has. And whenever I spoke to her on the phone, she was gonna email me. Oh, whenever I did have my first or my second Zoom appointment and I was sent to do a UA, she was gonna email me, everything like how she always does and lets me know everything. I wrote down the wrong date and I went on the wrong day. And then I actually went the week after she had told me. And then this last one, I was not working. I didn't work for like a whole month, almost pretty much. So honestly, right now, times are really rough with money. They've been like that. She was well aware that I was struggling to get employment and everything, which is why I fell behind on my stuff. But I tried to do what I needed to do. And I did tell her that, I was going to get back on track because I don't want to end up having to extend anything. I mean, it's already a pain to have to pay the breathalyzer fee every month. It's like $140, and then my probation. And then, I mean, I do have my home, I do have my car, I do have my bills. So it has been tough, but I'm getting back on track of that. So, I mean, I told her, I mean, if I have to be extended, then I mean, I really have no choice on that. But I told her, now that I have this new job, I was gonna start being, current on everything. Like I said, I have been blowing pretty much every day, my three breaths that she told me to do. At first, I didn't really understand what's it called? Like the rules of it. I thought it was only like 3 breaths. Like, if I just drive one way, like, 3 breaths and I'm good for the day. Because usually that's what I would do. I would drive, to the shop and it was 3 breaths and I was good. And no, she ended up telling me that it was 3 times a day, which that's what messed me up a lot too.
Oh, you didn't understand the rules or you were confused from Lifesaver or from from probation?
Pretty much both. Like I didn't understand whether it was just because this is my first, it was my first offense of DWI. So I didn't know if it was 3 times. Like, if I drive from here to the store, I don't know if those 3 times was good enough. Like that's what I was doing. I was just driving, when I wasn't working, I was driving to the store, to Walmart, to HEB and blowing 3 times. And I thought I was good, but I wasn't. It was 3 times a day. And then while I was out working, I would leave for 2 or 3 days sometimes and I wouldn't blow. Or on the weekends, I was only working Monday through Friday. On the weekends, I would just be home and my truck would be parked. So I didn't understand that.
Okay. Officer Keeling, what were those dates again for the failure to submit on the 15th of April, and what are the other dates?
It was the 15th of April, the 21st of April, and the 14th of June.
Okay. With the UAs that have been taken, you've provided, Mr. Arevalo, are those going to be negative?
Oh, yeah, I'm going to be clear. I'm going to be good. Yes, ma'am.
Are they going to
no
be
problem.
negative?
Yes, ma'am. They should be. They will be negative.
Okay.
Whenever I took the first one I submitted, that same day I submitted for my job, and I still have my job, so I know I'm clean. And then last time I reported was on July 3rd, I believe. I went that same day. Another reason why it was a conflict for me to go is because recovery was only due until 4:00, and I got off my job at 3:15. By the time I would drive 45 minutes down there, I wasn't able to get in. So now I asked my PO if I was able to go to the one off San Pedro, and that one actually working out way better for me. But I guess the results aren't coming in on time. Like she's been waiting for my June result, and we're already in this almost second week of July.
Okay. And you said there were no TAP recommendations, right, Officer Keeling?
Yes, Your Honor. There was no TAP recommendations.
All right. And fees are paid in full?
No, Your Honor. He's paid $124 towards his fees.
Oh.
And he's delinquent $508 right now. He was assessed $1,307.
All righty. Okay, so this case expires when again, please?
It expires on February 5th of 2023.
Okay. Mr. Arevalo, it's okay, we go ahead and go with the recommendations of the, I'm gonna go with the recommendations of the CSO right now. And we're gonna reset this and see how you do. Okay?
Yes, ma'am.
How long should I reset it for? A couple months, 2, 3 months? About 2 months?
Yeah, I would agree with 2 months.
All right. And CSO, would you mind, your recommendations are very good. Do you mind if I knock off a month on the extension?
Yes, of course, that's fine.
Would that be okay?
Yes,
All
sir.
right. Okay, now, Ms. Arevalo, make sure that you understand the instructions now and the rules.
Yes, ma'am.
Okay,
So
Now,
we're
may-
gonna be reset. Oh, I'm sorry, go ahead.
right, but you understand the rules as far as using your ignition interlock properly and the UAs and submitting and all that, right?
Yes, ma'am.
And
understand it's
you've
310%.
heard, and you heard as far as the dilution.
Yes, ma'am.
To go ahead and prevent dilution, stop drinking about an hour before. Already, and
Yes, ma'am.
it sounds like you are on track. You know, you got a little bit of a bump in the road, little misunderstanding, getting started on this. Like you said, it's kind of your first time, so you're kind of just feeling things out, right?
Yes, ma'am.
Alrighty, okay. So we'll go ahead and check on you in about 2 months, how you're doing, and just extend your ignition interlock for 2 months. And the CSO, if the 29 June and the 5 July UA comes out negative as he predicts that they would you go ahead and just do 1 month on the bi-monthly?
Sorry, can you repeat that?
If his UAs, he's already submitted UAs on the 29th of June and the 5th of July, right?
Yes, ma'am.
We're pending the results. If
Yes.
he says that they're going to be negative,
Mhm.
those two UAs, he says they're going to be negative.
Yes, Your Honor.
If they are negative, if they do come out negative, do you mind just because you've recommended UA for 60 days bi-monthly?
Mhm.
Do you mind
Bi-weekly,
just
yes.
say again?
Yes, Your Honor.
Do you mind knocking off 1 month?
Just so I can make sure I understand you clearly. So we would do bi-weekly UAs for 30 days instead of the 60?
Right,
Correct, that's fine. Yes.
that would work?
Yes, Your Honor.
Yes, that's pending the results and what you see.
Yes, Your Honor.
Okay. Mr. Arevalo has a very good attitude. He seems like he really wants to be successful on probation. Am I reading you right, Mr. Arevalo?
Yes, ma'am.
Okay, you want to go ahead and do this. So had a few bumps, changed jobs, and now you are on track, correct?
Yes, ma'am. I am.
All righty, very good. On track for success. I like that. Got a better job, doing good work.
Yes, ma'am, I do.
Well, I thank you so much for all that you're doing and contributing to the community in a positive manner. Okay? And we'll see you in about 2 months, okay, sir?
Okay, ma'am. So if so my 6 months were to end in August, so now it's extended 2 more months. So that is October. And whenever we have this review again, if I'm good till then, would I be able to get it off?
Right. You talk to your CSO about that. That's what we're looking at.
Okay, and then for the UAs, they would start next time I go and report, right? Or
yeah, right. Your
Okay.
CSO has the plan for that. Yes.
All right, ma'am. Then I understand everything.
Okay, good. Want you to be very clear. Any questions that you have, if you want to meet with your CSO in a breakout room right now, if you have any questions, make sure that you're clear on everything, okay?
Yes, ma'am. I'm good on everything.
You're what?
I'm good on everything. I understand everything now.
Okay, all right, it's very good. That's important. Okay, then.
Okay,
CSO,
Judge.
CSO, anything further?
No, Your Honor.
Okay, very good report. Thank you very much. CLO, any question? Please, any instructions?
Yes, I have a question. You were saying, okay, so the CSO was recommending bi-weekly drug testing for 60 days. So you want to do bi-weekly drug testing for 30 days?
No, I thought you said bi-monthly.
she was recommending bi-weekly drug testing for 60 days.
That would be 2 times a week.
No, bi-weekly would be 2 times a month.
That would be, I regard those as bi-monthly. You cut them in
Yeah.
half every 2 weeks.
Yes, Your Honor.
Okay.
Interchange
So-
of words.
Okay, so we mean every couple of weeks, right?
So during my office visits with him, I'll give him specific days on when to drug test. And he would have to abide by the days that I give him.
Okay, that'll work.
However, I just want to make sure we're super clear. If these 2 UAs that he has previously done, if they come out negative, then we'll only do the biweekly drug testing for 30 days instead of the 60.
If they're negative, if they're not, then we're going to go to 60 days. Okay?
Yes, Your Honor. Sounds good.
All right. Fantastic. All righty. Anything, any further instructions? CLO?
Yes. Now, Ms. Avella, I will be sending you your amending condition through Adobe. Could you please sign and date and return to me? Okay.
Yes, ma'am.
I will reset you in 2 months. Just look for the setting form that your CSO will send you as well.
Okay.
Okay, thank you.
Thank you.
All righty. Thank you, Mr. Alvarado. You're excused. Thank you.
Thank you, ma'am. Have a good day.
You too. You know what, CLO and Officer Keeling, I'm looking at that. I'm typing this into the dictionary bi-monthly. Do you know how it's defined? It says twice a month or every 2 months. Those are 2 different things. Twice a month is every 2 weeks, right? Or every 2 months, that's crazy definition. So I always understood it to be every 2 weeks. Let me see what they say about bi-weekly. Bi-weekly.
For clarification.
Right. Bi-weekly is every 2 weeks or twice a week.
It seems like 2 completely different things that they're
Isn't
trying
it?
to cover with one word.
It is.
Uh-huh.
It's 2 different. Wow. So we'll have to go with twice a month. We're gonna do twice a month or once a week or every 2 weeks. That's crazy.
So how would I word it? And so it would be
twice a month.
twice
2
a month.
times
Okay.
Right.
Twice a month. So he won't get
Right, because I've been using that bi-monthly, bi-annual. I've been using that all this time, and no wonder. Let's see, biannual is gonna probably be the same thing.
So UA's twice a month for 30 days.
Right.
Okay.
And see, biannual says occurring twice a year, period. It doesn't give you or, it says period, 2 times in a year. That's it. Tell you. What do you think? Attorney O'Donnell is here. But Officer Keeling, thank you very much. Great report. Appreciate your time.
Thank you, Judge.
All right. And you're excused. Thank you. Yes, sir. You're here for.
An inmate, she has 4 cases. One shows jail. I filed for competency and then she was released.
Oh.
Now she's back there and I verified again today, she's not doing well. She's not talking to people. She's competency is appropriate at this time, I would ask the court to sign those so we can get the script for others involved.
Okay, do we have anybody else? Officer Jennings?
Yes, we have one more.
Okay.
That's Neve Santiago Omar.
Alrighty. Thank you.
Thank you very much.
Alrighty. Neve Santiago? Officer Jennings, did you say
Yes,
Neve?
The
Neve
CSO is
Santiago
here.
Omar?
Yeah, the CSO is here, but not the probationer or his attorney.
Okay. Let's go ahead and get on record on cause number 642-252, State of Texas versus Omar Santiago Neves. Is that
Yes.
okay? Parties, please approach and identify who's before the court, starting with the CLO.
Ashley Jennings, Court Liaison Officer for County Court at Law Number 2.
Isara Olmos, Community Supervision Officer for Mr. Omar Nieves Santiago.
And Officer Jennings, when's the last court? Is Mr. Neves here?
I'm not showing he's on Zoom. No.
Okay. And I don't see anybody waiting in the breakout room. Officer Almost, did you advise Mr. Neves of this hearing today?
Yes, Your Honor.
How did you advise him of the hearing?
He was made aware about a week ago and he signed the case setting form. Also, I spoke to him this afternoon at around 1:30 p.m. and reminded him of the court hearing.
And you said you did speak with him today?
Yes, Your Honor.
About what time?
1:30, we had the monthly Zoom meeting.
Oh, okay, that was an office visit with him?
Yes, it was over Zoom.
Okay.
Yes, ma'am.
And did he acknowledge to you that he was going to come?
Yes, Your Honor.
Okay, so, and since you were meeting with him via Zoom, he knows how to use Zoom
Correct.
and he's Zoom savvy.
Yes, Your Honor.
Okay. All righty. So, when's the last court visit that we had with Mr. Neves?
The last hearing was held on March 8th, 2022. Mr. Santiago was granted on October 13th, 2020 for deferred adjudication for driving while intoxicated for 12 months and has been extended twice for a total of 12 months. On July 26, 2021, extended for 6 months, and on March 13, 2022, another 6 months. This case is set to expire on October 12, 2022. Your Honor, you requested a hearing for a status update. You wanted the probationer to read articles on money management and develop a financial plan. Judge, you would like the CSO and probation to review the IVR line instruction.
Okay, how has he been doing?
Since
CSO?
Yes, Your Honor. Since the last compliance hearing, Mr. Nieves has not submitted any urinalysis exams. He has failed to submit 8 since March 9th, and he has failed to call the IVR line 18 times. Mr. Nieves is also in lockout with the portable alcohol monitoring device since April 21st.
Was this an adjudication for DWI? You said it was granted on 13 October 2020 for 12 months.
Yes, Your Honor.
Was it straight probation?
No, deferred. It was a deferred adjudication.
You say he has failed to submit 6 times?
8 times.
How else has he been doing on probation?
Mr. Nieves obtained the PAM device February the 21st, and he recorded 41 skip tests from February 21st to March 20th. And from March 23rd to April 22nd, he recorded 93 skip tests. He has not made any payments towards probation or court fees, and has failed to submit non-driving affidavits.
Do you suspect he's driving?
He has stated there wasn't, they don't have a vehicle at his home. He say they get rides from his mother-in-law.
Okay, and how else is he doing on the rest of his probation requirements?
He has completed all the other conditions of probation. He completed the DWI education, the U impact, the community service hours, and the parenting class.
Alrighty. You say he has completed his classes?
Yes, Your Honor.
Okay. That's you impact DWI education or what?
Yes, you impact DWI education and parenting class.
And did he go under TAP? Did TAP have any recommendations?
He did complete a TAP on October 19, 2020. And let me just double check. They recommended supportive outpatient treatment, but it's at this time being held in abeyance.
And payments, his fees?
The last payment he made was
What's the
September 21. He has a balance of $1,385.
And so what was the total fees assessed?
1,524.
And he's paid how much?
139.
And he reports to you monthly. He reports to you, okay?
Yes, Your Honor.
Okay. Okay, and what are your recommendations?
Probation is recommending to term case upon expiration.
Say again?
Probation is recommended to term the case unsatisfactory upon expiration in October 12th.
To
Terminate the case unsatisfactory.
No, that SOP that was supportive outpatient, that's going to, we're going to have that. We're going to remove that from, we're no longer going to hold that in abeyance. We're going to activate that. He'll have to go ahead and complete the SOP. Is he working?
No, Your Honor. Today he told me he was working for hardware or restoration hardware for about 2 months. This was back in March, but he said the employer lost the contract and he is no longer working there.
Does he have like an extensive history that's preventing him from finding a steady job? I mean, with everybody looking for people to work.
He told me it's the lack of transportation, and he also told me he hurt his hand, and that's the reason why he hasn't been able to find employment.
A lack of transportation and what else?
And he also told me he hurt his hand, and that's the reason why he hasn't been able to find employment. He does have a cast. I saw it today.
Hmm. I'd like to also refer him to Bear County Reentry Center. He needs to go there and see what services would be. I wish I had their calendar or list of services that they provide. I used to get that on a steady basis, but I don't have it. But I wish for him to go there and see any services that they would be able to assist him with. So he must go there.
Yes, Your Honor.
Mhm. Officer Jennings, you said the last court visit was when?
Last court visit was held on March 8th, 2022.
Okay, let's go ahead and reset him for the end of this month. Please, CSO, if you would go ahead and tell Mr. Neves that he does need to attend these. Otherwise, could be considered failure to appear. And that might just, that may end up in a warrant for his arrest. If he can't help him if he doesn't show up.
Yes, Your Honor.
It's easy to show up. Okay?
Yes,
So
Your
he
Honor.
needs to come to the next one and let's find out what's going on with him. And he needs to submit to a UA. May need to go ahead and do a hair follicle. Who is the portable alcohol? Who's the vendor with the portable alcohol monitoring device?
He has Alcaloc.
Alcaloc, ALCO.
LOCK.
Okay. Please advise him as far as the financial analysis. We're just needing that in order to be able to see if we can help him with as far as the payments for the portable alcohol monitoring device.
Okay. Yes, Your Honor.
Ooh, we need to go ahead and be able to submit that, but he needs to show up. Okay?
Yes, ma'am.
Alrighty. Anything else?
No, Your Honor.
Alrighty. Officer Jennings?
That's it, Your Honor.
Alrighty. Well, thank you so much. Appreciate it.
Thank you.
Officer Jennings, do you have any others?
Oh, that's it for today, Your Honor.
Okay. Okay, anything as far as